All right. What is going on, Bree Hive? Welcome back to another live stream. How is everyone doing today? It is Thursday. We missed streaming on Tuesday, but we are back here this Thursday to cover some of the cases that we have covered in the past. Um, but there's some updates. There's some updates which we do not get a lot because cases take forever to get resolved. But surprisingly, these particular cases already have a resolution going on, even though they opened like earlier this year or like late last year. So if you guys are watching live, make sure you drop it in the comments. Let me know that you are here live. I know I was late putting the stream up today, but we're still here. We made it. It's all right. We are going to be covering, like I said, 3 lawsuits that have closed. We may get into the Diddy lawsuit. I haven't had time to really review it, but we are going to be talking about the Velveeta, 90-second macaroni and cheese false claim allegation. We're going to be talking about that lawsuit. We're going to be talking about Chipotle, who sued like a small business who also sold a burrito bowl. We covered that on this channel. So if you have not if you did not see that video, make sure you check it out. I probably should have dropped the link to the videos that we covered in the description box, but I didn't. If Kimmy has time, if you can drop the links to those videos that talk about these cases in the description. And for those of you who do not know, Kimmy is our channel paralegal, and she has been helping me out on the channel, getting documents together, keeping me on track. Without her, we probably would not be here tonight. So everyone, make sure to say thank you to Kimmy. We are going, I think we talked about Chipotle, Velveeta, and Subway, where the guy was talking about, they said it was all real tuna. Turns out they found traces of chicken, all kinds of things. We're going to be talking about that case as well. And then if you don't know, the Diddy case, we may or may not get to. It's the same Tequila case, where he's saying the company he contracted with is not really promoting his brand in the way that they should be. And he wants them to promote his brand. They actually countersued, and they also had a hearing. So I don't know if we're going to be able to get into it because the transcript is quite long and I did not have time to review it. But if we have time, we will jump right into it, y'all. And I'm telling you, I'm so nervous. I'm trying to get my little streaming room set up, and that's why I was a little late today. I'm trying to get my streaming room set up. So I have my camera on a different stand, and it is making me so nervous, y'all. So please hope that I put the stand up correctly and that our camera doesn't come tumbling down today. All right, we got some people popping into the chat, so I am going to see who is here with us watching live before we go ahead and jump into the case. Y'all, I got some like cute. I think it's cute. We got a little sign that's coming. It should be here next week. And I also have to update you guys on next week as well. I will not be here. We will not be live streaming on at least Thursday. We may be able to squeeze one in on Tuesday. I'll get into that in a little bit. But like I said, yeah, we got a little sign coming that's going to be here. And we're going to change the ambiance of the live stream. I'm super excited about that. Super excited to get everything together because right now my streaming room looks a hot mess. It looks crazy. So I'm excited to tell y'all about that and get that together for us. All right, we have Z Seltzer, a member of the channel. Hello, welcome to the live stream. Nice to see you today. We got Kimmy Locker, a channel paralegal. Welcome into the live stream and backstage. It's good to have you here today, and thank you again for getting everything together today because we probably wouldn't have made it. We were going to do Reddit. Reddit is always the easy, let's get in there, let's judge people. We got Ashley Hempel saying, I've not caught a live in a while. Another member of the channel. Well, welcome in. I'm glad that you're able to catch a live. I have been a little flaky myself, but it's okay. We're happy to have you here. Ari, welcome into the live stream saying, I'm finally catching a live after all this time. Like I just said, we've been a little wobbly here, so we are happy to have you here as well. Tanya D, another member and moderator of the channel, saying hello, and welcome into the live stream. Nice to have you here tonight. Kimmy Locker says, yay, good to see Ashley Hempel. Yes, making it in. I know everyone gets busy. It's okay. Deacon Fatal says, we made it, and it still gives me, what did you make? I don't know what you're talking about, Deacon Fatal, another member and moderator of the channel. Welcome into the live stream. Tanya D says, glad you're here to Ashley and Ari. Yes, of course. Deacon Fatal says, I don't want to eat food anymore. I'm sorry that you're going through whatever you're going through over there. We got Deacon Fatal saying, oh, thank you, Kimmy. Yes, thank you, Kimmy. Always our new channel paralegal helping me out. We're going to get this channel. We're going to get this channel off the ground. We got to get Kimmy a paycheck, y'all. We got to get her a paycheck because she does a lot of work for me. So we got to get this channel taken off. All right. Tiny D saying thanks to Kimmy. Yes, Ari saying, wow, thanks, Kimmy. Yes, she got all this stuff for us. So yeah, make sure you say the thanks. Kimmy Locker says, Bree's too kind. I'm having a blast helping out. Well, I'm glad. I'm super glad because I need the help. Mary Malarkey says, oh, what a nice surprise. Hello, Bree in chat. Hello, welcome into the live stream. Nice to see you tonight. Deacon Fatal says, oh, Diddy did that mess. Yeah. He sued them and they sued him back. So I'm hoping, because the updates on the cases are not that long, so maybe we will have time to get to them. Deacon Fatal has been a member for 15 months. I cannot even believe that I have been streaming for 15 months or maybe more. I don't know, but thank you for supporting the channel and being a member for 15 months and helping me push to keep this thing going, because it's hard. It's hard being full-time worker and also live streaming on the side, but at night. So I thank you so much for being a member for 15 months. I definitely appreciate it. Asher's mama says, hello, everyone. Hello, and welcome into the live stream. Nice to see you tonight. Deacon Fatal with a $20 super chat. Thank you so much for the super chat. Much, much appreciated. Saying 10 for you and 10 for the paralegal. I'm assuming that's what it says. Well, thank you very much. Definitely appreciate it. We're gonna have to set Kimmy up a cash app on the live stream. Thank you again for the super chat. That was very, very, very generous. Deacon Fatal says, I said what I said. The paralegal. What? Which one do you mean? Tanya D says to Deacon Fatal, I've been a zombie for the past 2 weeks. Tanya, when I tell you, that's what I feel like. Like, I am running on fumes at this point. Like, I've been to court several times this week. I have to go to court again tomorrow. I am like only sleeping 3 hours. So I feel you on that. Been like a zombie. Ari says, side note, I thought the Velveeta case got thrown out a while ago. I don't know. I didn't look at the dates. Maybe. I didn't look at the dates, but it's always good to update, right? I don't think we've updated on this channel, at least. Deacon Fatal says, for 84 years. And Mary Malarkey says, question, did you start the channel during the JD Amber Heard trial? No, I actually started the channel at the beginning of January. I started January 2021, but I was not live streaming yet. I was making like videos on like trademark law and business law because that's what like I was into. But then I started wanting to live stream. I was doing the more business videos because I was running my own business. Now I just do this for fun. And it's nice that sometimes it brings some dollars to help me out. But for the most part, I was just trying to do educational content. I started live streaming at the beginning of 2022. January 2022, but I was not that consistent. I got more consistent around Amber Heard and Johnny Depp, and that's when my channel actually started to take off too. So there is a little history on the Bree Hive. So started 2021 making random videos, which actually those random videos are really good revenue producing on YouTube. So I got to keep them up even though they do not match the style of the channel anymore. And then 2022 started live streaming, and now we're here in 2023 trying to get the channel to actually take off and be consistent. Kimmy saying heart to Deacon. Deacon Fatal says fumes and vibes. Yes. That's where we are at this point. Kimmy saying Velveeta was dismissed on 7/27, so at the end of July. So not too long ago. Deacon Fatal says to Kimmy, I have been running on fumes and vibes for the last 20 years. I believe it. I believe it. I'm starting my journey to fumes and vibes. And I've said this on my channel before, but I don't understand why when I was a child, time went by so slow. Like I felt like it took forever to get through a year. But now that I'm an adult, it just it just speeds. It just speeds on by. I don't know what it is. And I would like for time to slow down just a little bit so I can breathe, so I can sleep. That would be nice. So I can have some time. When I get off of work, I just want to do nothing. Or I work till 6, 7, 8 o'clock sometimes, and then I'm tired and I can't even do what I like to do on the side. Tanya D says, not sure how long I'll last tonight. I took an Advil PM. Well, make sure you get some rest. We're happy to have you here while you're awake, but you can leave it playing while you're asleep too. No, we definitely appreciate you being here. I know our streams are getting later and later. Kimmy says, Deacon Fado, are there people who don't run on fumes and vibes? I don't think so. Not once you hit a certain age, I swear. Tanya D says, your trademark videos have been helpful for me. Keep them up. I think they're really good videos. It's really good. But I do think that live streaming is easier. You don't have to be as polished. I felt like I was too polished in those videos, but those videos are really good if you are looking to trademark or even start a business. Deacon Fado doing a thumbs up for Tanya D, agreeing with the comment. Deacon Fado says to me, I am still asking my mom about his mess, the tequila case with Diddy. I feel he cheated. Who? Wait, what? Which one are you talking about? Now, here is, I think I tell my mom about this every day because she is happy. Well, I'm happy that your mom is happy, but I don't know what you're talking about. I might have missed your comment. I don't know. Are you talking about Diddy cheated or what are we talking about? Okay, let me go ahead and jump. Oh, wait. Let me remind myself, if you guys have not hit the like button, please do hit the like button. It helps us out in the algorithm. If you're not subscribed, please do subscribe. That also helps us out in the algorithm and also helps us get more friends so that we can laugh and giggle in the middle of the night when we should probably be washing the dishes or something. Okay, let's go ahead and jump into the case. We're going to start with Chipotle. If you remember this case, Chipotle sued as like a small business, but I don't know if they were like really a small business because I feel like they had a couple of locations, if I remember correctly, for basically promoting a burrito bowl. Chipotle basically felt like they are the owners. Well, I guess they are the owners because I believe they have a trademark of the burrito bowl, and they did not want this small company using the burrito bowl to advertise their product. The issue that I have with that case is that they will say this is a chicken burrito bowl. They are literally describing what it is that they're selling. But since Chipotle has a trademark on it, you can't use it, even though it's descriptive because it technically wasn't descriptive at the time that they filed for the trademark. But now it is. It's literally you put a burrito, all the contents of a burrito into a bowl. It's very simple. It's very descriptive. They're not doing anything special. They're not calling, like my face, a burrito bowl. They're calling contents that would normally go into a burrito bowl. Sounds descriptive to me, but apparently Chipotle does not think so. So let's go ahead and check out. This one is really short. It's only one page. Really short. So Chipotle Mexican Grill Incorporated sues Sweet Green, who were selling those chicken burrito bowls that really just pissed Chipotle off. Don't know why. They didn't like it. They don't want people stealing their flow and confusing Chipotle with this small business. They say pursuant to 41A1A1, A1AI of the Federal Rules of Civil Procedure, plaintiffs Chipotle Mexican Grill and CMG Pepper LLC hereby give notice of a voluntary dismissal with prejudice of all claims against defendant Sweet Green asserted in the complaint, as said defendant has neither answered nor filed a motion for summary judgment in this action. Now, they're dismissing it with prejudice. Maybe because they feel like they can't recover. What they're wanting them to do is stop. Did they stop? That's what I would like to know. Did they actually stop, or did Chipotle just give up because they never showed up in the case? Because they could, if they don't respond, could file a default against them and get a judgment that way. So I'm wondering why they dismissed it with prejudice rather than without prejudice. Are they going to try to sue them somewhere else? Do they think they have the wrong address? Do they think they served the wrong person? I'm wondering why they decided to go ahead and dismiss it with prejudice, and they did not explain it to us, and there's only one page. And the other party didn't answer, so I don't know. Kimmy, did you find any more information about this? Because I'm just like, why did they just cut it off? Why did they just cut it off? Yeah. Oh, and for those of you that have not noticed, I am not streaming on TikTok today because I was running behind trying to set up my camera and being very scared that it might fall down. Okay. All right. Let me go ahead and jump into the chat and see what the chat is saying. Kimmy is dropping the link to the previous Chipotle video. I don't think I can copy it here off of StreamYard. Can I copy it off of the other one? I need to drop it into, well, I can save it for later, I guess. I need to drop it into the description box on YouTube. But I don't want to mess nothing up. Let's see. Open in a new tab. YouTube Studio. Okay, we got something going on here. I'm just trying to put the link in the description. Edit. But the thing is, I would have to be able, oh, here we go. Copy link. Got it. Okay, we got the link to Chipotle. And y'all also got to stand for my mic so I don't have to knock it down all the time. Oh, and Kimmy made a ticker for us. Thank you. Got the work going on. Chipotle. And then a link. Sorry, y'all. Not having my stuff together before the live stream is, common occurrence here. Okay. So now it is in the description box. If you guys do want to check out the live stream going over the entire complaint for that case. All right. Now I'm going to jump back into my live stream. That's the link. I am going up. Kimmy says, oh, okay. I will probably have to resend it, Kimmy. Or I guess I could just, no, I can't type and do this all at the same time. I have to resend it after the live stream. Okay, let's see where we at. Okay, here we go. Here we go. Mary Malarkey says, I'll show your trademark video some love and like. Thank you very much. I appreciate it. Deacon Fatal says, by adultering. By adultering was a lie. I don't know what you're referring to. I really don't know. Who are you talking about? Who are we talking about? Ashley Hempel says, healthy choice has an unwrapped burrito bowl. Chipotle might be after them next. They better watch out. They better watch out. Deacon Fatal says, is this kind of like appropriation? They're basically saying like trademark infringement or what do you call it? Slipping my mind right now. Unfair business competition, deceptive business practices. Yeah, they're alleging those kind of things. Soka, am I saying your name right? Soka Toa says, hi, hello, welcome into the live stream. I'm so excited for you guys to see my the sign that I got for the channel. I'm so excited. Soka Toa's chat reminded me of the sign. Rachel Mills, hello, welcome onto the live stream, saying who jumped up Chipotle's you know what and made them want to do this. They are trying to protect their brand. They want to have a strong hold on the burrito bowl, but there are so many companies that are calling it burrito bowl at this point. They're going to be suing forever. I think that's kind of similar to like the boneless wings and not necessarily like trademark infringement, but not wanting people or not wanting companies to call boneless wings because it comes from chicken breasts rather than actual chicken wings. We also covered that case. I need to see if there's an update over there. Sakatoa says, hi to Deacon Fato. Mary Malarkey says, thanks for the link. Yes, of course. Thank you for sharing that link. Deacon Fato says, you still haven't told me who you're talking about. Kimmy Locker says, I didn't see anything else, but I can look a little deeper. Yeah, I would love to know, like, what happened? They just said, okay, we're going to dismiss it with prejudice because they didn't respond. Like, did they sue in the wrong spot? You don't have to, like, go crazy trying to find it. But I'm just wondering why they decide to dismiss with prejudice, or did they just change the name of the bowl? And remember, this one, I can't remember exactly what it was, but they had multiple words within the sentence. It wasn't just like burrito bowl. It was like chicken. What was like chicken? Oh, you know what? I think it was like chicken Chipotle burrito. Describing the flavor of Chipotle. I think it had Chipotle in it too. That might be why. That might be why. Mary Veronica says, love the ticker. Very nice. Thank you. I tried to use them, but Kimmy helped us out and got it on there. I was supposed to set it up before the stream, but I was too busy trying to make sure my camera didn't fall down. Kimmy Lucas says, Bree set up the colors, so I just typed it in. Yes, of course. Yeah, the theme is already set up. Need to get some sounds in the background, but we're going to get that soundboard by the end of the year, maybe a Christmas present. We're going to get it, though. Cheryl C., hello. Welcome into the live stream. Nice to see you tonight. Kimmy Locker says, it is safe to assume your sign doesn't have the slogan we came up with during the last No, it does not have the... It absolutely does not. It says, I'll give you a hint. It does say Bree Hive, but it's just like super cutesy. And I'm super excited to change the ambience of the actual live. We're going to go for like a more dark, since we stream at night, like a darker screen versus this bright white light that we have on right now. So hopefully it turns out the way that I'm envisioning it. Welcome in. Sokatoa says, yes, you are saying it right. It's a trigonometry neum. I don't know what that means, but but I'm glad that I'm saying it right. Rachel Mill says, maybe people can name them taco bowls. Yeah, I guess it's not bad, right? Because you kind of put the same things. You can literally put the same things in a burrito and a taco, but Chipotle doesn't want you naming it I think it's like burrito bowl, chicken. Oh, it was chicken Chipotle burrito bowl. It's something of that nature, if I remember correctly. Mnemonic device. Okay. In the back of my head, I know what that means, but I can't think of it right now. Fumes and vibes, y'all. Fumes and vibes. Like Dick Fatal says. Ari says, I think it was like Chipotle chicken bowl or something like that. Yeah. Oh, yeah. It was. Oh, it didn't actually have burrito bowl? I don't remember. I should have probably watched my own live stream before I live stream, but I didn't have time. I don't have enough time. Ashley Hempel says, I mean, Chipotle is a pepper, isn't it? That's why I said it's descriptive. Like, you're just describing the flavor. There's Chipotle sauce that's not by Chipotle. So I don't know what their big dealio is. And Cheryl C says, I'm not sure how long I'll make it tonight. I am inexplicably exhausted. And a lot of people on the stream are, so we just appreciate you for popping in, even if you don't last the whole stream. I don't even think this is going to be a long stream just because I'm exhausted myself. I'll just leave the stream running, but if I go silent, I fell asleep. No problem. Tanya D says, oh yeah, we discussed if Chipotle is a spice or just the name of the company. Yes. Did you know about the company before you knew about the season or the spice? Or the pepper, or the actual pepper. And I learned about the company before I actually learned about Chipotle. But in my defense, I was a child when I learned about the Chipotle restaurant. I was not very well versed in peppers. Okay, so I don't know if that would be the defense for everyone in the scenario. Kimmy Locker says, "Oh my gosh, to Ahsoka Tano flashback," and I feel like it does sound familiar. I'll have to look it up once I get home. Chelsea says, I'm catching up on 2 times speed. It looks like we are both half asleep tonight. Yeah, to Tanya D. Yeah, a lot of us are. Sakatoa says, I hope it's not a bad flashback to Kimmy. Kimmy says, I like trig. I like math in general, though. Off topic, because that's what we do in the Bree Hive. We swarm around and maybe not get to the honey quick enough. I took, what was it? Advanced, what did they call it? AP, Advanced Placement Calculus. Because I took trig, I took Algebra 2, by the time I got into high school, I think I was in algebra, then algebra 2, then trig, and then AP calculus. And when I tell you that I cried every day in that class, I literally cried every day in that class. Like, it was the worst of it. And it was like a class full of like all juniors and maybe like 2 or 3 seniors. And I was one of the seniors. I hated that class. Hated it. I literally just filled in bubbles at the end of I literally just filled in bubbles at the end of the last test, the final. And I'm pretty sure the teacher probably just gave me a grade and was like, here, go on about your life. You passed every other class. I had like all A's and B's. I graduated with like a 3.97. But what brought me down was that C. I got a C in calculus. And not only did I cry in that class every day, including guessing on the final, my teacher tried to convince me to take the actual AP test. I said, lady, I'm not wasting my money. Why would I waste my money and take the AP? Do you not see me crying? I know you see me crying every time I take a test because I don't know the answer. I don't know what I'm doing. This calculator doesn't work properly. The calculator doesn't work properly, and you want me to pay 80 some odd dollars to take an AP calculus test just so I can fail it? No. And I know she saw me crying because my desk was like literally right in front of her desk. Like 3 other students were sitting in front of me. I always sat on that side of the classroom. So I know she saw those tears. I know she saw those tears. But Trig was nice. Trig was fun. Okay. Thank you, Kimmy. I see in the back, which got us all the links. Sokata says hi to Cheryl. Mary Malaki, sorry for getting so off topic, y'all. A rant. Mary Malaki says, yes, I learned about the pepper from this group. From this group on Beehive? Or from a different group? Tanya D says, same to Mary Malarkey. As far as the Chipotle, Deacon Fatal says, I have a final paper to finish, and this case reminds of Candy Crush trying to trademark candy. Such an obvious name, right? Kimmy Locker says, I did AP statistics. It was either calc or statistics. That was like the senior level math. I did AP statistics instead of calc, so maybe that's why I still like math. Maybe. But a lot of people also hated statistics. So I don't know. I don't know if we even had AP statistics. We had statistics, but I don't know if we had AP. Cheryl C says to Kimmy Locker, I love math. I just could not get into trig. Never will. I ever need to know the code. I don't even know how to say it. No, is it cosine or tangent of anything, much less a negative number? LOL. That is also true. I like trig. It wasn't that. I got a good grade in trig. I believe I got an A in trig. Calculus, I for sure got a C. Okay? Love Dreaming Peach Cat. Hello, welcome into the live stream. Nice to see you tonight. Deacon Fiddle says, I did all the maths and forgot them after I got out of school. Yeah, exactly. Because we just need to know how to add. And half the time we're pulling out a calculator for that. We are all the way off topic. I don't think we're going to make it into Diddy because we're talking about math now. I used to say that math was my favorite subject in school too, but probably once I hit, no, I like trig still, but probably I hit trig, it was not my favorite. Kimmy Locker says, I use negative numbers when I want to express something sarcastically, but that's about it. You're a negative 10. That's a negative 10 if I had to vote. Deacon Fiddle says, geometry is still my favorite class. I took geometry, but geometry was in high school. So I didn't take I took algebra in middle school. But yeah, I took geometry too. Mary Malarkey says, I haven't admitted this to my family, to Tanya D. Secretary says, oh, but you did. Yay, I cried in English class, so I feel you. That is so tough. Like, why do they put us through these things? They teach us such useless stuff. Like, I don't understand. And obviously, like, especially like health education, where they told people how not to have babies, and everybody I know has a baby already. That class didn't work. And I tell you, we took that in 5th grade, 6th grade, 7th grade, 8th grade, and 11th grade. We took it times. And we still had teen pregnancy. So I don't know if that class is very helpful. Deacon Fiddle says, I know I have to take statistics soon. Good luck on that. Don't be afraid. You got it. You got it. You like math, you'll get it. Love Dream and Peace says, Crying in Calculus by Boss. We can do a series. Not a serious. We can do a series on that. Crying in Calculus by Boss Bree. Positivity Bree cries in calculus. Don't y'all go spreading that on the internet. Deacon Photo says, my mom teaches math and we both don't like statistics. I never took statistics, so I don't know how bad it is. So Katoa says, sorry to throw everyone off topic. I did what... You did throw everyone off topic. You have to think about who's the culprit when we get off topic, and at least you admit it to being the culprit. Sorry to throw everyone off topic. I did want to add that Chipotle is pretty spicy pepper and it's delicious. I've never actually had a Chipotle pepper like outside of Chipotle seasoning, so that might be fun to try. And you guys, you know what? Which we haven't updated on in a while. We need to do an update on the case. Mr. Beast Burgers. I saw his cookies in Walmart and I was so tempted to buy it so that we could try it on the live, or so that I could try it on the live stream. But he has cookies in Walmart. And I was like, should I look for the other company who also said that sued him, saying that they were copying him? The D's Nuts case. Remember that one? They're supposed to also be in Walmart. So maybe I'll go try to find these nuts. And Mr. Beast cookies. Let's not turn it into a Boss Attorney Bree After Dark stream. Akiruki, hello. Welcome into the live stream. Nice to see you tonight. Mary Malarkey says, yeah, you kids had calculators, not... I think about this all the time. Like when I'm researching for work, I'm like, imagine if I had to look through books, which we did. They did teach us how to look through the books in law school. Hated it. Hated every second of it. Ashley Hempel says, I hated geometry, but loved algebra. And shout out to whoever is hitting the like button on the iPhone device. You can hit the like button within the chat. That's always cool. It's kind of far off to the side, so shout out to whoever was just making the hearts bubble. It's not on all phones now. I know it started on iPhone. Saying that's awesome. Love Dream and Peaches. Actually, I was just getting quite heated and angry that they're still making my kids they have the same books that my father was reading in the 50s. Like, why are they not updating the curriculum? Not okay. They need to start teaching more like practical things, not these math classes. I'm sorry, not these nuts. Okay. Kimmy Locker says to Mary Malarkey, we had calculators, but teachers used to say we had to learn to do things without them because it's not like we were going to carry calculators in our pocket everywhere. And that's all we do. All we do is carry a calculator, a map, a freaking weather machine, a computer. My husband asks me all the time, hey babe, what does this mean? What does this mean? I'm like, I don't know. You have a computer in your pocket. That's like my favorite line. You have a computer in your pocket. Look it up. Deacon Fiddle says it wasn't me this time. No, it was not. You did not throw us off track. Aki Ruki says, I saw these nuts bars in my Aussie supermarket the other day. The discount shelf. Not the discount shelf. Mr. Beast is going downhill. Oh my gosh. Mary Malarkey says, Catholic school didn't teach us about how not to have babies. They fixed it by having the boys and girls sit on opposite sides of the classrooms because that's very effective. What happens when you go out of school? Kimmy Locker says, the cat, they updated the Common Core in Georgia and it was terrible, so it just got worse. Kimmy Locker says, not when I was in school, but for my niece. Okay, fair enough. That's fine. Saying the Common Core sucks. My nephew learned that. Is that the new math that they're teaching? I don't know. Jazzy G says, hey, chat and Bree. Hope everyone is doing well. Hello. Welcome into the live stream. Nice to have you here tonight. Guys, if you haven't already, I know we got off track. Okay, we were all off in a whole nother country. If you haven't already, please do hit the like button and hit subscribe if you're not subscribed because we're trying to get back on track. Let's go ahead and jump into our next case. The case that we just covered, Chipotle got dismissed with prejudice. Don't know why. I would really like to know why. Okay, getting rid of Chipotle. Should we go talk about Subway and the fake meats? Or should we talk about Velveeta with the macaroni and cheese not heating up fast enough? I probably should have asked this while I was off track and maybe created a poll, but it's too late to do that. So we're going to go eeny, meeny, miny, mo. We're going to go with, let's go with Velveeta because it has more pages. Okay. Let's see. We got a chat. Kimmy Locker sharing some info with us. Saying Chipotle dropped the lawsuit because Sweet Green agreed to rename their burrito. Well, that makes sense. That makes sense. So they entered into a stipulation. That's why I was like, it doesn't really make sense for them just to cancel it because they didn't answer or request summary judgment. So they put kind of like strange reasoning in there. So thank you for finding that. They entered a stipulation and they changed the name. That's good. That's good. Chelsea says, okay, I'm caught up with the live stream. Well, welcome into real time, kind of, because on YouTube, you're a little bit more delayed than real life so that we can have our closed captioning. Ashley Hempel says, I'm not going to make it much longer. I have to get up early and take my mom for surgery. Well, I hope her surgery goes well. No problem. We're happy that you were able to pop in. Mary Malarkey goes Subway, but I already picked Velveeta, so that's what we're going to cover. Jesse G saying hi to Kimmy. Okay, let's go ahead and I keep looking at my lips because I need some Carmex or something. Water or something. Okay. We are gonna share our screen and make it a little bit bigger. Boom. Okay, there we go. We got Amanda Ramirez suing Kraft Heinz Foods Company, which also owns Velveeta. This calls, this is an order on the motion to dismiss. They moved to dismiss the case. Let me check my private chat. Oh, yep, got it. Thank you, Kimmy. It's hard to multitask. All right, we got a new ticker, and I spelled Velveeta in the actual title wrong and still didn't fix it. I realized it before I posted it, but didn't fix it still, so I have to fix that later. Yes, we are covering Velveeta 3-minute mac and cheese, a lawsuit, an order on a motion to dismiss. This causes before the court upon defendants Kraft Heinz Foods Company motion to dismiss plaintiff's complaint. Why? Plaintiff is complaining that her mac and cheese was not ready in 90 seconds. Okay? Plaintiff Amanda Ramirez filed a response in opposition, to which defendants filed a reply, to which the plaintiff filed an opposition. No, I'm just kidding. The court scheduled a hearing on the motion and heard oral argument on July 11, 2023. The court has considered the motion, all opposing and supporting submissions, the parties' oral arguments, the record in this case, the applicable law, and is otherwise fully advised for the reasons set forth below. Why are they dropping this case? Plaintiff filed her class action complaint, hoping that other people would join in with her being mad about more than 90-second mac and cheese. Therein, plaintiff alleges that she purchased defendant's microwavable single-serve cups of mac and cheese between October and November 2022, among other times. Plaintiff claims that the product is marketed as ready in 3.5 minutes, but the statement is false and misleading because the product takes longer than 3.5 minutes to prepare for consumption. Plaintiff included the following pictures on the box and the directions on the back. Oh, this, I forgot. I love covering. I like refreshing without going to watch it. Well, I don't know. I don't watch my own videos because I don't have time. But I forgot. She was mad that she first had to prepare it and then put it in the microwave for another 3.5 minutes. So we got directions. Remove lid and cheese sauce pouch. Add water to the fill line in the cup and stir. Microwave uncovered for 3.5 minutes and do not drain. Stir in the contents of the cheese sauce pouch. So she doesn't want to do all those extra steps and still have to wait 3.5 minutes for it to get warmed up. According to the directions on the back of the package, there are 4 steps in preparing the product. Plaintiff further alleges that the directions outlined above show that 3.5 minutes is just the length of time to complete one of several steps. All 4 steps sound, you just put it in there dry and see what happens, ma'am. Just put it in there dry and blow your microwave up or catch it on fire. Like, what are you talking about? The complaint alleges that consumers are misled to expect that the product will be ready for consumption in a shorter amount of time than it really takes to prepare. Boo freaking who, lady? Why don't you learn how to cook real mac and cheese and stop worrying about the 3-minute mac and cheese? Those facts form the basis of 7 claims against defendants: violation of Florida deceptive and unfair trade practices, false and misleading advertising, breaches of express warranty, implied warranty of merchantability and fitness for a particular purpose, and Magnuson-Moss warranty pursuant that statute, negligent misrepresentation, fraud, and unjust enrichment. Plaintiff seeks monetary and injunctive relief together with cost and attorney's fees. In the motion, defendant seeks dismissal of the complaint and argues plaintiff's claim failed to plausibly allege consumers' deception regarding the product's labeling. Plaintiff lacks standing because she suffered no injury. She had to wait an extra 30 seconds to put water in the cup. To open the package, first of all, she had to open the package. Opening the package was one of the steps. So did she not want to have to open the package? How was she supposed to eat it? Literally opening the package was one of the steps. So she suffered no injury because she put freaking water in a cup and put it in the microwave. That makes sense. Plaintiff's tag-along claims should be dismissed because all are based on the same defective theory of deception, and plaintiff lacks standing to sue for injunctive relief. Plaintiff responds that none of the defendant's arguments provide a basis for dismissal and the motion should be denied. Defendants filed a reply in support of its motion. The standard, it would just basically have to, for a summary judgment, not summary judgment, okay, let me go back because I'm trying to think of it. To delete the case, to cancel the case on a 12B6 motion, you must establish that they have standing to sue. It is a question of whether the litigant is entitled to have the court decide the merits of the dispute of the particular case. So let's see. Standing requirement. We're not going to read all of that. Indeed, standing is a threshold question that must be explored at the outset of the case. The court is not free to opine. To establish standing, the plaintiff must allege it suffered an injury, in fact, that is concrete and particularized, and B, actual or imminent, not conjectural or hypothetical. The injury is fairly traceable to conduct of the defendant, and 3, it is likely not just merely speculative that the injury will be redressed by the favorable decision. The party invoking federal jurisdiction bears the burden of proving standing, blah, blah, blah. We're not going through that. As far as 12B motion, to survive a motion to dismiss for failure to state a claim. Oh, wait, did I miss? I might have missed some stuff. No, this is all just citing cases. So, okay. To survive a motion to dismiss for failure to state a claim under 12B6, a pleading in a civil action must contain a short and plain statement of the claim showing that the pleader is entitled to relief. Although a complaint does not need detailed factual allegations, it must provide more than labels and conclusions, and a formulaic recitation of the elements of the cause of action will not do. You have to actually say, this happened to me, thus I satisfy the claim. Pleading depends. Nor can a complaint rest on naked assertions. You made me wait longer than 3.5 minutes, so I'm suing you. Devoid of further factual enhancement. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on the face. When defendant moves to dismiss for failure to state a claim upon which relief can be granted under 12B6, the court must accept the plaintiff's allegations as true and evaluate all possible inferences derived from those facts in favor of the plaintiff. So the court, for whatever reason, did not think that she actually stated a claim when she went ahead and filed this complaint. 3 minutes is 180 seconds. Thank you, Kimmy. So they're alleging 3.5 minutes that it was not done in. So the court does not believe that she was able to state her claim. Maybe she doesn't have standing. This is a live reaction. I don't know what their decision is going to be. So let's go ahead and jump into the discussion and see why the court is deciding that this case should not move forward. Okay, let me go back into my chats to see what the peeps are saying. Ashley Himble says this was such a dumb lawsuit. Apparently the court thought so too. Aki Ricky says by her hoax reading of this lawsuit was comedy gold. I haven't seen his rendition of the Velveeta case. Ashley Himble says, adding water and stirring takes at least another 30 seconds. And that was 30 seconds too long. She already took 5 seconds to open the package. Now we're at 4 minutes and 5 seconds. It's just too much. And you also have to press the buttons on the microwave. Don't forget that part. You got to press the buttons on the microwave. So you might be at 4:15 or so. Granted, you don't mess up with the numbers. It's just too much. I agree with her. No, I don't. Mary Malaki says, this case is ridiculous. It is ridiculous. Kat says, it's pretty obvious this girl has time to waste. She got a lot of time on her hands. She is not running on fumes and vibes. She is running on no vibes, okay? And no fumes. She has adequate rest and a lot of time to file motions. Tanya D says, time and money, obviously. Yes, she does. Mary Malaki says, Bree, why don't you learn how to cook grilled mac and cheese? Mic drop. That is true. It would definitely take more than 3.5 minutes. That is true. Oh, live reactions get me caught up. I'm glad I'm not big enough to where people start clipping my ridiculousness on live stream. Okay, let's see what the discussion is. As noted above, defendants moved to dismiss the complaint, arguing that plaintiff has not plausibly alleged consumer deception and lacks standing to bring her claims for damage and injunctive relief. Plaintiff responds that her consumer deception claims are plausible. She has standing as she sufficiently alleged injury, waiting an extra 30 seconds, ma'am. And her complaint should not be dismissed because she has to wait 30 seconds. She didn't say, I thought I only had 5 minutes for my lunch break and I used it all heating up my mac and cheese. I only had 5 minutes for my lunch break and I used it all heating up this mac and cheese because I couldn't figure out how to put water in a cup. Because the issue is standing is a threshold jurisdictional question, the court first addresses the parties' arguments as to Article 3 of standing. Okay, the lack of injury. Defendant argues that plaintiff lacks standing because she suffered no injury. Specifically, defendants argue that plaintiff has not plausibly alleged she did not receive the benefit of her bargain and that she continued to purchase the product after becoming aware of the allegedly deceptive cook time. She did say that she bought it multiple times. She did buy it multiple times, so I wonder if she tried to heat it up without the water initially and was wondering why it didn't taste good or why her microwave was catching on fire because she wasn't following the directions. She did say she bought it from October to November. So she bought it, in my opinion, she bought it a couple of times. Plaintiff responds that she sufficiently alleged that she paid a premium price due to the misrepresentation and the price premium allegations are sufficient to establish standing. What premium price, ma'am? What premium price? Plaintiff alleged that she paid more for the product that she would have paid and would not have purchased it or paid less had she known it was going to take 4 minutes instead of 3.5. I get her pain. And you know what? She probably has to wait for it to cool down too so that she doesn't burn her mouth. So it's probably more like 6 minutes at this point. Whew. She got to wait for it to cool down. Defendant cites 2 other distinct court cases from the circuit where the court found that similarly situated plaintiffs lacking standing. All of these cases against all of these people, against Pfizer, against Kimberly Clark. And I know Kimberly Clark to be like the paper towel holder thing. I might be wrong. Pfizer gave us the COVID vaccine. In Prohias, the court considered a motion to dismiss a complaint in which plaintiffs allege Pfizer engaged in misleading advertising campaign that created an artificial demand for Lipitor, raising the price and causing economic injury to Lipitor. Oh no. Come back. Where did I go? Okay, here we go. The court found that the plaintiffs lacked standing despite having pled price inflation theories of damages, which is what my homegirl is claiming, that she paid a premium price. The Prohias court stated that because plaintiffs obviously believe that they continue to receive benefit from taking Lipitor, notwithstanding any alleged limitations as to the efficacy, yeah, that is right, and continue to pay the price charged by Pfizer and its distributors to show any damage under the price inflation theory would require evidence of a hypothetical price at which Lipitor would sell if not for the allegedly misleading advertisement. Similarly, in Sweeney, the court considered whether the plaintiff had standing to pursue a FDUTPA claim under a price premium theory for damages where she purchased wipes which the manufacturer alleged misrepresented as flushable. That court found that the fact that plaintiffs continue to purchase and use the defendant's flushable wipes make their theory of damages too speculative to constitute an actual injury. The Sweeney court specifically found that plaintiffs lacked standing to prosecute under this letters, I don't know what they stand for, claim under a price premium theory because the undisputed facts and record evidence demonstrate that they continue to pay the alleged price premium despite their knowledge and belief that the wipes are not flushable. Same thing with her. She knew that it did take more than 3.5 minutes to finish making the food, so she could not have been injured because she kept buying it. Maybe if she bought it once, maybe she would have passed, is what the court is saying. In her response, plaintiff contends that she did not continue to purchase the product after learning that the label was deceptive. However, that contention is refuted by the complaint. Plaintiff alleges that she purchased the product at locations including Publix between October, or Publix, Halea. Publix, Halea is the city. Between October and 2022, among other times, is what she said. Emphasis added. That allegation closely mirrors the allegations the Prohias and Sweeney courts considered. Here, as in those cases, the allegations demonstrate that the plaintiff continued to pay the alleged price premium, knowing that the product was not actually capable of being ready for consumption in 3.5 minutes. She contradicted herself. In her own document, she contradicted herself. As such, plaintiff was not deprived of the benefit of her bargain. Plaintiff cites Bulk and Shearer's Foods, where a court in the district found that the plaintiff's allegation that she paid a price premium for products is all that is required to be pled under the federal rules of civil procedure. Plaintiff is correct that in that case, the court found that plaintiff had adequately alleged damages because she alleged that she paid a price premium for the products due to the all-natural and no artificial ingredients. However, Bulk is distinguishable because plaintiff also alleged that the misbranding on the products at issue rendered those products valueless. Here, although plaintiff has pled a similar price premium allegation, plaintiff has also pled that she continued to purchase the product on multiple occasions. Therefore, it's not plausible that the product was rendered valueless. So she still liked it, basically. She still liked it enough to buy it again, even though it was taking her more like 4 to 5 minutes versus 3.5, like the package said. Plaintiff's reliance on PSIC is similarly unpersuasive, and PSIC, I don't know why I'm saying it that aggressively. The court in the district found that plaintiff adequately pled a concrete economic injury where he alleged that he paid a premium price for a misleading labeled product. The plaintiff argued that he did not, in fact, receive the benefit of the bargain because the hand sanitizer he purchased would not have killed 99.9% of all germs. What What goes across people's mind? Like, I have never took some soap or some hand sanitizer, put it on my hands, rubbed it together, and said, you know what? I think there's about 95% of germs still left. I'm going to sue them. What are you looking at the ingredients? How are you coming to this conclusion? Here, by contrast, plaintiff alleged that she purchased the product over the course of 2 months, among other times, rendering it implausible that plaintiff did not believe she had received the benefit of her bargain. Plaintiff also has not alleged the hypothetical price the product should sell for, considering it may take longer to prepare than a consumer may be led to believe. So, in her opinion, it should be cheaper. Therefore, the price premium theory of damages is too speculative based upon the allegations in the complaint. This case is analogous with the Velvetta. Recently found that plaintiff's allegation that Publix honey lemon cough drops caused him economic loss resulting from the product's misleading advertisement did not suffice to the alleged injury in fact. The court specifically noted that plaintiff in that case did not allege that the cough drops were defective, did not work as advertised, or otherwise were so flawed to render it worthless, and in fact suggests that he purchased the product on more than one occasion. Very, very similar to what this lady did. The Valiente court went to find that plaintiff does not allege any facts by which one might measure the premium price he claims to have paid and the cough drop fair market price. The court held that where the plaintiff complaint is devoid of any factual support for the idea that the product is in fact worth less than the stated price, the mere allegation of having paid a price premium due to the purportedly misleading labeling was not sufficient to plead an injury of fact. You can't just say it was overpriced. They go on to say the same is true here. Plaintiff alleged as a result of the false misleading representation, the product is sold as a premium price, approximately no less than $10.99 for 8 2.39 ounce cups, excluding tax, and sells higher than similar products represented in the non-misleading way, and higher than it would have sold for absent the misleading representations and omissions. She does not allege that she was unable to consume the product or that it was otherwise so flawed as to render it useless. She was still able to eat it, even if she had to wait an extra 30 seconds so that she could put water in the cup so that she did not burn down her house, okay? In fact, the complaint does not even include an allegation that plaintiff ever attempted to cook the product. Did she try to speed race cook it, court? Is that what you want her to do? Speed race? Let me see if I can get it done in 90 seconds or whatever it is. Oh, that's why you told me 180 seconds. I just got it, Kimmy. I just got it. Because I keep saying 90. It's not 90 seconds, 3 minutes, girl. Similarly, plaintiff's complaint contains no factual allegations of the price she might have paid if defendant's product was not marketed as ready in 3.5 minutes. Therefore, plaintiff has failed to demonstrate an injury and lacks standing for her claim. I'm not saying all them letters. And tag along claims. All right, they're going to get into standing for injunctive relief. Do we want to read all of that? Okay. Maybe. No, I don't think I want to read all of that. I think it's going to say the same thing, but we can skim it. Let me see what the chat is saying because I've been kind of rambling for a moment. So let's see what the peeps are saying. Okay, let's see. The FDU TPA. Can you let us know? It's called Florida's Deceptive and Unfair Trade Practices Act. Oh, that's too many darn letters. See? No, I guess it includes a lot of things. So fine. Okay. Where are we at? Kimmy Walker says, sweet dreams to Deacon Fatal. Good night, Deacon Fatal. Hope I didn't miss you. I feel like you're always preparing for an exam. I'm hoping school is going good for her. Ashley Hempel says, night, good luck. Tiny says, what is the premium? $129. $129 too high for her. Ashley Hippo said, no, they're more like $250 now. Kat says somebody poorly advised her and she had nothing better to do with her time than waste it and her money. It's I can see why she filed it. Her attorney probably just didn't know about these cases and they did not know Kraft was going to be coming out swinging. But I don't know why they didn't know that, because Kraft has been around for so long. You don't think they have money for lawyers that can sweep you under the rug? You don't think they've been advised on this before they put that labeling on there? Come on. Love, Dream, and Peace says somebody poorly. Oh, I already read that. I'll waste their money. Yeah, some lawyers just want money, honestly. Mary Malaki says I wouldn't go up against Kimberly Clark. Yeah, they got a lot of standing, for lack of a better word, behind them. Jazzy G says such a waste. Yeah. Tidy says dang to Ashley Hempel. She better go to the $+ tree next time. Get a lower price. Mary Malarkey says, can you imagine the lawyers who took the case? Did they have a choice? Yes, you can deny a case. You don't have to take a case because someone comes to you. This is a civil case. Now, criminally, if you are a criminal defense attorney who is appointed by the court, if you don't have a reason behind it, then those are more situations where you can't deny it. But I think there are some ways to get out of it, but don't quote me because I'm not a criminal attorney. But in civil, you don't have to take people's cases if you don't like them. If you just don't like the way they look, well, you can't be racist. But if you just don't like the way they look, you don't have to take their case, right? Aki Rookie says, plaintiff really liked the Velveeta shells and cheese, is how Hogue summarized that part, basically. She kept buying it. Ashley Hempel says, how is a bargain also a premium price? I don't know. She wants the benefit of her bargain. It's saying that it's going to take her less time, so she wants to pay a higher price in order to get the benefit of her bargain. Aki Rookie says to Ashley Hempel, maybe it had a discount tag, but the price was still higher than the dollar store. Yeah, I don't remember what I read, to tell y'all the truth. Probably shouldn't have gone to that store. Akiriki says this entire lawsuit could be summed up as didn't want to shop at a cheaper place, or she wants them to lower the prices so she can keep buying it because she really, really likes the mac and cheese. Mary Malaki says, can't imagine what happened when plaintiff goes to a restaurant. Oh, she's sending it back for sure. She is sending it back. Hella Swanky says, oh, wow, Def got no notification tonight. Well, apologies, Beehive. Hello, everyone. I was just thinking, where is Hella Swanky? I was like, oh, maybe she got something to do. Wrong. No, I'm just kidding. It's okay. We've been live streaming probably about an hour, so you haven't missed that much, but kind of missed much. Nice to see you tonight. Happy to have you. Hella Swanky, another member and moderator of the channel. Welcome into the live stream. Late is okay, saying Kimmy Locker saying stinky YouTube. Glad you made it, Taylor Swanky. Ashley Hempel says, or take 30 more seconds of her time. It probably was like an extra minute drive to the dollar store to get what she was looking for, to get the price she was looking for. Kimmy Locker says, isn't her attorney responsibility to know that or at least find out? Yes and no. So a lot of being an attorney is about researching, and it could very well be that she went with like a younger attorney that wouldn't know these type of things, because she could have easily left out that she bought it on more than one occasion, and then her claim probably would have found the test. Could it have failed when it's time to go to trial and they can file another motion for summary judgment because they're not going to be able to establish their claim because in discovery they found out she bought it more than once? Sure. But if her attorney is new, or they just don't know, or they think that they have a stronger argument, we see that she filed a reply, so they probably still felt like they had a good argument, and they thought they could persuade the judge. A lot of it is like, yes, this is law, but a lot of this is up to interpretation for a judge because it's a case. If you're looking at cases, not statute. If you buy something you don't like, it is law that they have to give you the money back. That is not what's happening here. This is a case. It's kind of up to interpretation, if that makes sense. Like, okay, in this case, they bought it 3 times. Is this more similar to a homeboy that bought it 1 time or a homegirl that bought it 5 times? And it's up to the judge to decide that. And this judge didn't even say how many times. It just said she bought it on multiple occasions. So she must have liked it. So it wasn't valueless. She ate a couple of noodles, 8 packages here and there. Is what the judge said there. Ari says, on a mac and cheese note, I found a mac and cheese candle. What? Why would you want that? And TJ Maxx the other day, truly the most horrific candle I ever smelled. I can only imagine what that smelled like. Oh my gosh. Because I don't know. Some of you on YouTube may know I worked at Jelly Belly. And like when you make the bean boozled freaking jelly beans, smells so nasty. And I'm thinking about the buttered popcorn. What you think? You go to a movie theater and you're like, butter popcorn, salt, butter, smells good at the movie theaters. But making a butter popcorn jelly bean, sickening, okay? So I can only imagine what that candle would have been like. So I am sorry that you had to smell that. I don't know what possessed you to smell it, but I'm sorry you had that experience. Kat says, I used to work for Nabisco in 1999 until they got bought out by Kraft, and Kraft is doing a thing. Kat says, I used to, until they got bought out by Kraft. You didn't want to stay with Kraft? Tiny says, glad you made it to Hella Swinky because my meds kicked in. Tiny about to be knocked out. Z Seltzer says, I saw the other streams that the plaintiff lawyer in the case entire practice is bringing suits like this. Well, he sucks then. If that's the case, then he sucks, or he just thought he could persuade the judge. Aki Ricky says, I feel queasy just reading your description of it. The mac and cheese candle. Yeah, Tanya D's going to sleep. Before I go, shout out to the replay crew. Make sure you hit the like button to support the Beehive. Yes, thank you for the reminder. And have a good night, Tanya D. We appreciate your help in moderating this chat. We got pretty good people in tonight and a couple of moderators in today. So you rest easy knowing that you got people here that have your back. We definitely appreciate you and hope to see you. I have to make sure that we stream on Tuesday because I will not be here next Thursday. I will be going to homecoming for my alma mater. So I'm going to be turned up all weekend and I will not have time to stream. a little mini vacation for me. So I'll see you on Tuesday, Tanya D, but we will not be here on Thursday. Okay, Kimmy Locker says, have a good night to Tanya D. Ashley Hempel says to Z Seltzer, I saw that too, and now I try to see the law firm each frivolous food lawsuit. That's probably what's happening, huh? Kat says, I make vegan mac and cheese for my kids, and it takes hella long. I can believe that. Cheryl C says, I detest the butter popcorn jelly beans. Yuck. A lot of people really like that jelly bean. Don't know why, but I also don't really like jelly beans at all. So, yeah, a lot of people like that. So, with the jelly beans and the Bean Boozled, and you do that little Bean Boozled game, there's the butter popcorn and then the vomit, I believe. No, it's not the vomit. It's the earwax. I believe earwax. If you have not looked at Bean Boozled, look it up. I believe the earwax is the same color as the popcorn one. And I'm just like, well, which one is the better out of the two? Is it the bean? Is it the earwax or is it the popcorn? I don't know. I wouldn't know. But at the same time, I don't know. I never played the game. I was too scared to play that game. Sounds gross. But people liked it. Kids really liked it. Kimmy Locker says to Z Seltzer, I wonder when the attorney decided to dedicate their career to cases like this. Did they go through 3 years of law school knowing it'd be applied to nonsense? Maybe sometimes they win or at least make it to a lot of times what they're doing is like making it to a settlement. So maybe they don't go to trial. Like 1 to 2% of cases actually make it to trial versus getting a settlement, right? So maybe he gets a lot of settlements just for it to go away, and that's the way he makes his money. I don't know. I'm just speculating. Aki Ruki says to Kimmy Locker, I guess at some point they decided that this was viable business model, and who cares about the pride in your work? Let me tell you, there are some very sketch lawyers out there. I'm not gonna lie to you. You see the cool ones over here on YouTube, but there are some sketch ones in actual practice. I deal with them on a daily basis. Kat says, not that I didn't want to stay with Kraft. They fired my entire, that makes sense, because it was a duplicate of what they already had, huh? Yeah, that makes sense. That tends to happen. Kimmy Locker says, dang, sorry to hear that to Kat. As far as the job, Tanya D says, don't party too hard and protect your feet. Breathe. Y'all are going to leave me alone. I have not injured myself in a while, but I will tell you the truth. My toe still hurts. I'm pretty sure it did break, but probably like a tiny little bone. But they said it's not broken. I think that it is broken. Kimmy Locker says, Bean Boozled sounds like a great member stream. Oh, no, ma'am. Not at all. Not at all. I am not playing that game. I'm not spending $10 on that box of jelly beans. Chelsea says the marshmallow ones is the same color as buttered popcorn. Marshmallows? No, buttered popcorn is supposed to be the bad one. Let me look it up. We gonna look it up. I worked. Watch me be loud and wrong again. Let's see. Let's go to jellybelly.com. Okay, here we go. Off topic again. Who caused this? Who caused it? Oh, me. I caused it this time. But I think it was Ari said she smelled a mac and cheese candle. So technically Ari caused it and I joined in. Oh, it looks like they have some new. I think they got some new flavors. Let's go. Share the screen, Brie. Get it together. Okay. So they got this green one is juicy pear or booger. You got strawberry banana smoothie or dead fish. I never heard about the dead fish one. Oh, we both were wrong. Cheryl C. We both were wrong. It's buttered popcorn and rotten egg. Yeah. There's an earwax one though too, or did they discontinue that one? Okay, let's keep going. Strawberry banana or dead fish. I can only imagine what that smells like when they. Oh my gosh, what that smells like when they make it. I don't ever remember that one. Berry blue or toothpaste. I thought that one was soap. Am I remembering wrong? Am I having like a Mandela effect right now? Birthday cake or dirty dishwater? I really never heard of that one. They must have upgraded to worse things. You got peach or barf. You got tutti frutti or stinky socks. Pomegranate or what? Or old Band-Aid? These are new. These were not around when I was around. Not when I was tour guiding. Pomegranate or old bandits? What the heck? Toasted marshmallow or stink bug? Yeah, these are new. These are for sure new. Cappuccino or liver and what? Liver and onion? And then butter, popcorn, and rotten egg. There used to be an earwax one too. So they must discontinue some stuff. This must be the upgraded version. Do they got like traditional and upgraded? Because this, I don't think this is what we had. Okay, so they do have different editions. So this is the 6th edition. They have all of these are 6th edition. So they must just be on another edition. Because I guess otherwise you will get bored and run out of nasty flavors to eat, I guess. Oh, that's gross. Okay.
That's enough of Jelly Belly reminiscing. All right, where we at? Yeah, so I think they upgraded. Now, I did not know that they upgraded it, and I worked there, so the more you know. Um, it is a cruel game to play with us, and everyone would have to buy their own box. So unless we have a stream meetup somewhere, Z Celsius says they want the settlement. Yeah, I would agree with that. Ashley Himbo says I need to know who at Jelly Bean Factory tasted all the gross stuff to get the taste right. We know it wasn't Bria. Sure, it wasn't me. It sure was not me. So typically what they do is that they mess up on something. So fun fact that I'm giving away on the internet. The bar flavor was made when they tried to make a pizza flavored jelly bean. Now, why would you want a pizza flavored jelly bean? I don't know, but they tried to make one. They tried to make a pizza flavored jelly bean. They tasted it. Apparently, someone thought it tastes like barf, and now it's the barf jelly bean. They decided to keep it for whatever reason. Okay. Cheryl C says, or maybe it was peach, not marshmallow. Either way, they are the same two colors, and that's just me. Yeah, that's the purpose of the game, is to trick you. Tiny D thought you was going to sleep. We traumatizing you. Tiny D says, who knows what earwax tastes like exactly? Exactly. I get Ricky says upgraded to worse things. Yeah, dead fish. That's way worse than anything else I've ever seen on there. So yeah, they're wild for that. Dirty bandage, like that's gross. Apparently Jelly Belly. D's laughing. Can't be like it says thanks. I hate it. Right. Right. Kat says, LOL, thanks for the condolences. It was 25 plus years ago and I'm over it. I thought this was recently. I thought this was like last week. You got me all worked up for nothing. Aki Ricky says, this sounds like a food masochist project ill. Yeah, they're just in there messing stuff up. Kat says, technically all the fish are dead. No, not when they're swimming, they're not dead. What do you mean by that? I mean, people who eat fish are eating. Oh yeah. Okay. Yes. Peach and bath. Now that's offensive. Which one was it? Peach and barf. Yeah. Yeah. They're gross. There used to be one that was soap. Toothpaste. It doesn't sound too bad when you're talking about all of the other ones. Honestly, it doesn't seem too bad. You got stinky socks. That one's still going. Barf hasn't gone anywhere. Booger hasn't gone anywhere. Dirty dishwater is new. Rotten egg hasn't gone anywhere. There was one that was earwax, but I think, I don't know which one earwax used to be. Either way, we're not doing it. So get that out of the minds. If you are considering doing that challenge on the channel, we are not doing it. Okay, let me go ahead and jump into the last lawsuit. We're going to skip the stuff about the injunctive relief on, which one was that one? Velveeta. She didn't prove her claim. She gets dismissed. I'm going to assume this next case is going to be pretty similar to that. This one is the Subway restaurant one where he was mad about the meat not being the meat they claimed it was. Okay, let's see here. We have the Northern District of California. We got a Cali case close to me in Northern California. Order granting plaintiff's motion to dismiss and denying defendant's motion for sanctions. Guys, I forgot to say, if you have not already yet, please do hit the like button. It helps us out in the algorithm, helps us get friends, it helps grow the beehive. Let's go ahead and jump into the case. Before the court are plaintiff Nilma Amin. This is the guy, if I'm not mistaken, the one that also sued Buffalo Wild Wings for the boneless wings that are not actually wing meat. It's chicken breast meat. Sorry, I forgot to text my husband. Okay. And they are suing Subway's franchise, the Subway's franchisee and trust fund. They had a motion for sanctions. The court will grant Amin's motion to dismiss and deny Subway's motion for sanctions. Wait, order granting plaintiff's motion to dismiss. Wait, why is he dismissing his own case? I didn't even realize that. He's dismissing his own case. Okay. Plaintiff in this putative class action contends that Subway misrepresents the contents of its tuna products. Before plaintiff filed the action, her counsel... Oh, so no, it's not the same person, because I believe the one with the other case is a guy. Before plaintiff filed the motion, her counsel, Salini Dogra, sent demand letters to Subway on behalf of another Subway customer, stating that her client intended to bring a class action against Subway for its unlawful, misleading, and deceptive advertising violations of the California Consumer Remedies Act. Subway sent a letter in response stating that its records indicate tuna menu items in Subway restaurants are in fact tuna. Missed it. Are in fact tuna, and your client has no basis for its claims. Okay, so it is a guy. Her counsel, his counsel. I think it is the same guy, but they put her up here and then him down here. Okay, whatever. And that because the demanded letter provided no basis for the claim, Subway has no reason to believe that the claims have any merit. Plaintiff Karen Donawa and Nilma Amin then filed the original complaint in this action on January 21st, 2021. They allege that Subway's tuna products did not contain tuna nor have any ingredients that constitute tuna. On March or April of 2021, Subway's counsel sent Amin's counsel's letter stating that any DNA testing of Subway's tuna products, including polymerase chain reaction testing, was unreliable, citing 2 scientific journal articles in support of the proposition. The letter also attached Subway's own testing showing that their tuna was in fact tuna and documents that purport to show the chain of custody of Subway's tuna. My thing is, you go there and you buy a sandwich and you eat the sandwich. At what point do you say, you know what? This is not really tuna. This is not really tuna. I am going to take this tuna to a lab for them to test if it is really tuna. At what point do you get... We all know this stuff that they feed us in America. It's not real. Maybe it's a little real, but they're feeding us some crazy stuff. But I'm not going to take it to a lab because guess what? I don't have no choice. I got to eat it anyway. I don't have to eat it, but you grow your own stuff or you die. I mean, what possessed them to do this? I don't get it. The letters also attached Subway's own testing. On June 7, 2021, Donowa and Amin filed an amended complaint alleging that Subway misrepresents its product as 100% tuna. So it is a little bit tuna. It's just not 100% tuna. Falsely claims that the tuna in its product contains either skyjack or yellowfin tuna from sustainably farmed fisheries and states that it has a global ban on the sale of tuna species that come from anything less than healthy stock, for example, albacore or tongal, which in fact the tuna products do not contain 100% skipjack or yellowtail tuna and or do not consist of 100% tuna. The court granted Subway's motion to dismiss the first amended complaint without prejudice, finding that the amended complaint failed to satisfy Rule 9b because it did not describe the specific statement that they relied on. When they saw the statements and where the statements appeared. So they're saying that they claimed it was 100% tuna, but there's like nowhere on Subway's sign that said 100% tuna, or at least the plaintiffs never told us where they saw these claims. On November 8, 2021, Donowa and Amin filed a second amended complaint alleging that Subway's tuna products partially or wholly lack tuna as an ingredient. What? You went from it's not tuna to, okay, it's not 100% tuna, but to now, you know what? It's not tuna at all again. Okay, fine. And that they contain other fish species, animal products, or not miscellaneous products aside from tuna. the court granted in part and denied in part Subway's motion to dismiss the second amended complaint. First, the court dismissed Danoa's claim with prejudice because the complaint did not allege any facts pertaining to Danoa, and plaintiffs failed to identify how this defect could be cured. So we're just left with Amin now, who is, if I remember correctly, the pro at filing these lawsuits or bringing these lawsuits. Second, the court dismissed Amin's theory that a reasonable consumer could understand the phrase tuna on the menu to mean that the tuna salad sandwich or wrap contains 100% tuna and nothing else. And we talked about this on the previous live stream. Most of the time when I go to the store and I'm getting a sandwich and I'm expecting to have a tuna sandwich, I'm expecting like tuna salad, not like a chunk of tuna sliced meat. The only time I'm expecting tuna is when I go to sushi and I order something with tuna in it. Ahi tuna, actually. So I don't know what they mean by that. If I'm ordering a tuna sandwich and I like tuna, I want the tuna salad. So that's my position on it. Because a reasonable consumer will not disregard the well-known fact of life that a tuna sandwich, salad, or wrap likely contains ingredients other than tuna. But it held that Amin's misrepresentation claims could proceed under her theory that the tuna products contain other fish species, animal species, or miscellaneous products like mayo. Because whether and to what extent a reasonable consumer expects cross-contact between various Subway ingredients is a question of fact. The court also held that the claims could proceed under Amin's theory that the tuna products wholly lack tuna as an ingredient, because a reasonable consumer would expect that a product advertises tuna to claim at least some tuna as ingredient. Finally, the court denied Subway's motion to dismiss under 9B federal out of the federal rules, holding that the complaint adequately alleged that who, what, when, and where. Okay. On July 28, 2022, Amin filed a third amended complaint alleging Subway statements were misleading, pursuant to the two theories that the court held had plausibly alleged. Subway answered the complaint on August 11, 2022. On November 1st, 2022, the court issued a scheduling order with deadlines for class certification, discovery, and motion practice. The schedule set May 25, 2023 as the deadline for Amin's class certification motion. The parties filed a joint discovery letter brief on March 10, 2023, which the undersigned referred to Magistrate Judge Elisa Cisneros. The parties' discovery dispute concerned whether by serving her discovery response late, Amin had waived her objection to defendants' interrogatories, document requests, and requests for admissions, had admitted the request for admissions, and was required to immediately provide completed responses without objections to defendants' written discovery, and produce all responsive documents in her possession, custody, or control. Judge Cisneros ordered the parties to supplement the joint letter by March 21, 2023 by submitting the discovery request and response at issue and a copy of the written communications and declarations by the plaintiffs. On March 21, 2023, Christina Wong, Subway counsel, submitted a declaration regarding discovery dispute, stating that Amin failed to respond to Subway's discovery request by the statutory deadline and had not requested an extension on the deadline. March 27, 2023, attorney Dogra filed an untimely declaration stating that she requested an extension from Wong before discovery was due. That Wong stated Subway expected the response after the deadline. This is saying a lot. I don't want to. And the discovery responses were delayed because Amin was experiencing some medical issues associated with her pregnancy. Wong then filed a subsequent declaration stating that Dogra's declaration was inaccurate. Did they spell her name different now? Inaccurate because the first time she ever spoke to Dogra or any counsel for a plaintiff was on February 20th, 2023, after the plaintiff's discovery response were already overdue during a meet and confer call regarding a different discovery matter where they did not discuss Amin's discovery response. Wong further stated that Dogra's representation that she told me that the plaintiff needed more time to respond was also untrue because Subway did not receive any communication from any of the plaintiff's counsel regarding the plaintiff's discovery responses until February 19th. They heard the issue, something about not being on time, something about dismissal. All right, let's get past that because that was talking too much. I'm like, I don't even know what's going on at this point. I don't even know what's going on at this point. Okay, Kimmy let us know it's not the same person that's in the Buffalo Wild Wings lawsuit. They just have very similar names. Thank you for updating us on that. Okay, let's see. Okay, a man requests that the court dismiss her case. Oh. She want to dismiss her own case? Why? I thought that was weird. I'm like, am I reading this wrong? I'm like, maybe the court wrote something wrong. But no, she's really trying to dismiss her own case. A man requests that the court dismiss her case pursuant 41A2 of the Federal Rules of Civil Procedure so that she can focus on her family and her health without the pressure of litigation, which has been complicated and distracted. And Subway was like, no, you sued us. You have to stay in this. And raise your family later. You should have thought about this before you got pregnant. What? A man argues that the action should be dismissed because her complaint was unequivocally filed in good faith and based on reasonable investigation, and Subway cannot establish any legal prejudice in having the case dismissed. They spent money, but the court's going to deny their money? Subway does not oppose dismissing the action, but argues that the court should dismiss it with prejudice, and to the extent the court does not grant Subway's motions for sanction, the court should order a man and her counsel to pay Subway's litigation expenses as a condition to dismissal. Subway further argues that if the court dismisses the action without prejudice, it should do so only on the following conditions: that Subway be awarded attorney's fees and costs, that Amin and her counsel be prohibited from naming any new plaintiffs or class certification experts in any subsequent action, that any subsequent claims by Amin or her attorneys and their law firms against Subway relating to tuna products be filed in the Northern District of California and assigned to Judge Tigar. In her reply, Amin contends in error that she never saw dismissal without prejudice and assumed that the court will dismiss the action with prejudice. In fact, Amin's motion to dismiss requested that the court dismiss her claims with prejudice. This lady, oh my gosh, has too much time on her hands. You sued them. Say, you know what? I just had a baby. Maybe I should focus on my family. Maybe you should have focused on your family before you started filing claims, claiming that your tuna salad was not tuna enough for you. Okay, fine. She wants to dismiss her claims. Subway basically wants to make sure she does not then bring the claim back against them at a later date. But whoever Subway's attorney is must have misread what she filed because she wanted to dismiss it with prejudice. She was over arguing about Subway's tuna and whether it was real or not. Okay? People are crazy. Rule 41A2 provides in relevant part that an action may be dismissed at the plaintiff's request only by a court order or terms that the court considers proper. The court treats Amin's reply brief as having abandoned her original request for a dismissal without prejudice and having conceded that dismissal with prejudice is appropriate, deeming abandonment of argument in reply as concession. Because the parties now effectively stipulate to dismissal with prejudice, Amin's motion for voluntary dismissal with prejudice is granted. The court next determines whether to impose fees and costs as a condition of dismissal. Although the issue has not been resolved in the Ninth Circuit, district courts have concluded that payment of fees and costs should not be imposed as a condition of voluntary dismissal with prejudice, absent exceptional circumstances pursuant to the rules of civil procedure. Dang, that's messed up. I'm glad I don't practice this kind of law. Since the cause of action has been dismissed with prejudice, costs and attorney's fees cannot be awarded to defendants because there is no future risk of litigation. Can they do it against the law firm though? No, they cannot have that blanket stop. Additionally, even if exceptional circumstances exist, the party requesting fees must establish an independent source of authority for an award, because in itself, it is not specific statutory authority for the imposition of sanctions against an attorney. So you can't stop the law firm from having someone else hire them and bring it to them, because it's not practical, or it's not normal for attorneys to actually be sued for trying to represent their client by another law firm. Subway offers only 28 USC 1927 and the court's inherent authority as basis for an award of attorneys. Because these are also basis for Subway's motions for sanction, the court considers Subway's arguments in connection with the motion as discussed below. The motion for sanction. Subway requests the court impose sanctions against Amin in the amount of attorney's fees and costs since the inception of the action, or at least its attorney's fees and costs since April 2021, pursuant the code and the court's inherent authority. Because she did waste their time and money, like, that is messed up. Subway argues that these sanctions are warranted because Amin's counsel's bad faith pursuit of a frivolous lawsuit, reckless misstatement of fact, lack of diligence in abiding by deadlines, and intentional misrepresentations to the court. Because remember, she also didn't respond to discovery, and then when she was getting in trouble for that, she said, you know what? I want to focus on my family. Let's just drop it. Let's just let it go. Amin responds that the court should not award sanctions because there were tribal issues of fact as to the DNA. True, the court found that she did have some viable claims to the DNA being sold as tuna, providing Amin and her counsel a significant good faith basis in moving forward with the lawsuit. Amin also argues that the amounts and description of work submitted by Subway in relation to the amounts they claim to have charged are bloated and inconsistent with any semblance of appropriateness. Under 1927, an attorney who so multiplies the proceeding in any case unreasonably and vexatiously may be required by the court to satisfy personally the excess cost, expense, and attorney's fees reasonably incurred by such conduct. Sanctions under 1927 may be imposed where an attorney knowingly and recklessly raises frivolous arguments or argues a meritorious claim for the purpose of harassing an opponent. They're not going to be able to prove that. In context of 1927, frivolousness should be understood as referring to legal or factual contentions so weak as to constitute objective evidence of improper purpose. Additionally, Section 1927 creates a duty to correct or withdraw litigation positions after it becomes obvious they are meritless. The district court authority to sanction attorneys under 1927 must be exercised with restraint and discretion. Additionally, while finding of recklessness suffices for 1927 sanctions, when acting under an inherent authority to impose sanctions, a district court must find either willful disobedience of the court or that a party has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. Sanctions ordered pursuant to court inherent authority are limited to fees the innocent party incurred solely because of the misconduct, or put another way, to the fees that parties would not have incurred but for the bad faith. Let's get away from all of these cases. Subway has not persuaded the court that the requested sanctions are appropriate under Section 1927 or the court's inherent authority. First Amendment's claims, at least in part, survived a motion to dismiss, so she technically had a valid claim. Holding that evidence sufficient to support summary judgment against plaintiff did not establish plaintiff's claims were without factual basis or asserted in bad faith, because the court determined that most of plaintiff's claims survived a motion to dismiss. Come on. Second, and more importantly, this is a big old paragraph. Subway's pre-lawsuit in March and April 2021 letters challenging the merits of Amin's claims are insufficient to demonstrate that Amin's counsel knowingly or recklessly pursued her claims. Amin's counsel has scientific testing concluding that the majority of samples of Subway tuna products contain no detectable sequence of tuna DNA and did contain detectable sequence of other animal DNA, as well as scientific journal articles supporting the reliability of the chosen testing. The DNA barcoding, blah, blah, blah. They process the samples. These factors make it a highly effective tool for detection of fish species in the can. They're talking about the type of testing. While Subway's evidence to the contrary may ultimately prove it more persuasive, the court cannot conclude that Subway's evidence made it obvious that Amin's claims were meritless and frivolous. So the court is basically saying, just because they had a potential of likely winning does not mean that it was completely meritless. She might have been able to come up and prove her case, right? We can't really say who would have won in the situation, is what the court is saying. Subway places great weight on plaintiff's counsel's litigation behavior, and the court agrees that Amin's counsel's conduct was blameworthy. Counsel failed to meet deadlines, including deadlines to serve discovery responses. Hello, they're opening a book for the client to actually sue the client to actually sue the attorney, rather than the other attorney suing the other attorney, or holding the client responsible for her attorney's conduct, because the attorney is the one with the professional responsibility, not the client. Counsel failed to meet deadlines, including deadlines to serve discovery responses, failed to serve expert disclosure, failed to file all the supplemental materials ordered by the judge, and filed an untimely and false declaration. Ooh, they call it false declaration with Judge Cisneros regarding the failure to comply with discovery deadlines, produced deficient discovery responses, served an improper deposition notice, and misstated the record in both their motion to dismiss and their opposition to Subway's motion for sanctions. But that does not, although her attorney sucks, that does not demonstrate that counsel acted recklessly or in bad faith when pursuing a men's claim before or after April 21. She's just stupid and not a good lawyer, is basically what the court said. The court cites a case. Dilatory tactics generally do not make plaintiff's case frivolous, unreasonable, or without foundation. Just because she sucks doesn't mean it's frivolous. Also, while Subway describes specific instances of attorney misconduct, its motion for sanction does not pertain to that conduct. Instead, Subway asked the court to award fees and costs because of counsel's continued pursuit of Amin's claim. Because Subway has failed to demonstrate that such pursuit constituted the knowing and reckless pursuit of meritless claim, the court denies the Subway's motion. But if they would have alleged that their attorney sucks and they delayed the process and messed up the process, rather than just saying that the claims are meritless, maybe, just maybe, it would have been exceptional circumstances in which the court could have awarded attorney's fees. But the court said, just because she missed deadlines, lied to the court, filed false documentation, yeah, she might get sued for malpractice. Oh my gosh. The court grants Amin's request for dismissal with prejudice, and the clerk shall close the file and enter judgment. Subway's motion for sanction is denied. Let me see what y'all saying in the chat. I know I was reading for a long time. I wanted to get through it, but let me see what's going on. What time is it? Okay, I was reading for a while. Okay, here we are, I think. Ashley Hempel says that has at least more merit than Velveeta. Yeah, I mean, they survived the motion to dismiss. Velveeta did not survive the motion to dismiss, so they're a little further in. Ashley Hempel says, never mind, just lost and merit. I don't know if I'm reading that right. Ari says, my mom's favorite thing at Subway is the tuna salad. I don't think I ever ate that from Subway, but I used to make it at home. Not the sick face. Kimmy Lockett says, didn't take long. Ashley Hempel says, well, it does have mayo. Yeah, they mix the mayo. Well, when I make it, I mix mayo, eggs, relish, mustard, all those things. Love Dreaming Peach says, question, I wonder how the dark act that Obama signed plays into this, because companies are allowed to hide some of their ingredients by law now, which I don't agree with, of course. I don't know. I'm trying to figure out where I need to sit. I gotta set my computer up better. I'm not too familiar with that particular law, but there are certain things that you can that food companies can allow in your food up to a certain amount of percent that they do not have to disclose, like bugs. bugs, spiders, all of those things. Hello, Swanky says to Kimmy Locker, hey, how are you? Y'all having a whole chat. Kat says, last week at the mall, we got vegan cheese on pizza, and there was chicken in the vegan cheese container. Should I sue? Just won't go back. Right. I mean, if you got the money to sue, you can be a case on our channel. Let me know if you sue. Kimmy Locker says, love Dream and Peach. I used to own a snack food manufacturer. How do you get into that? I was literally talking to my husband about that the other day. Like, how do you get into like manufacturing snacks that are distributed on a large basis? And things companies plan to get away with was frequently the topic of one or more conference presentations. Jeez, they were just putting on a whole show. So we are going to put skeletons into this cookie bar. Let me not say that. Kimmy says it's nuts. Kimmy says, though, you guys having your chat. Love Dream and Peach's cat says to Kimmy, yeah, once you work in restaurants, you learn how gross they really are. I don't like to think about it. I do not like to think about that. Hello, Swanky says to Kimmy, y'all having a whole combo. I'm not putting y'all on blast. Aki Rookie says, few stepped away to deal with a clean room air pressure crisis, catching up on 1.5 speed. Well, that's okay. I hope you got it all figured out. Hello, so he says, oh, the court sounds big mad. The court is not on Subway's side for whatever reason, but I don't know. Sometimes I think about being a judge, but I don't want the hate because I know I'd be mad. I'd be mad at the judges when they don't go in my way. Kimmy Locker says, Kat, I had to refresh my memory on the Dark Act, but I don't think it applies here. The Act instituted federal standards for GMO labeling. It didn't enable companies to hide. I'm not too familiar with it, so I can't really comment. Kitty says ingredients, but it gave them discretion regarding how they disclose info about ingredients being genetically engineered, which critics said makes it difficult for consumers to access the info. Okay, that makes sense. Kimmy says, if only the plaintiff lived in Ireland, their Supreme Court ruled that Subway's bread isn't actually bread because it contains too much sugar. Hey, the thing is, she didn't even go forward with her lawsuit. And apparently her attorney sucked so bad and probably causing her stress as she's trying to deal with her family. She didn't even make it to that point. She dismissed her own lawsuit. Like, that is wild. You went through like 2 years of litigation, and then you say, you know what? I'm gonna go be a stay-at-home mom. This litigation life is not for me. The litigation life is not for me. I cannot. Well, y'all, that is all I have for the live stream. I do intend on live streaming next Tuesday. I don't think I have any hearings on Tuesday. I can't remember. But I will see you guys all on the next live stream. Thank you guys so much for joining live. Let me know in the comments if you made it this far and you haven't hit the like button. Please do hit the like button. It really helps us out in the algorithm. If you are not subscribed, please do hit the subscribe button. We got to grow our followers so we can get more friends here in the Bree Hive so we can all have a good time laughing in the middle of the night when we probably should be sleeping. We probably should be sleeping. Like I said, I will see you on Tuesday. Let me not say the little phrase. I will see you on Tuesday and probably no stream Thursday. Should be back the Tuesday after that. I hope everyone gets a good night's rest, and thank you again for joining us live. I will see you on the next one.